Okay, we're going to start. We have 37 people on here already, so that's good. Let's go ahead and take a look at Real Estate Basics 101, and that's what this class is going to be each Thursday or whatever day we do it. I'm starting out by just taking the sales contract, and we're literally going to go line by line through the contract and discuss what it means, so that when you sit down with your buyers and your sellers, you'll be able to explain the contract to them. So Tuesday will be Ask Larry. This class is really for concentrating on the basics. Somebody had a question?
720 contract, right? Residential sales contract.
It
720.
should say
right?
7/20/20. They sent it out yesterday, a package that says 7/20/20, or the bottom of the contract will say 7/20. Okay? So first thing to understand this sales contract, the very first thing is understanding how to read it. And I know that sounds kind of strange, but what I'm after, if you've been in class with me around here, you know when a word is capitalized, what does that mean in this sales contract? Well, it means there is a written definition that both buyer and seller have agreed to. I don't care what the agents want it to say. This is what buyer and seller have agreed to. So I want to start out with paragraph 31 on page 11 of your contract. And it's called definitions. And you'll see like data ratification, quotation marks. That is the definition. So we will take a look at what data ratification means. Right now, I just want to cover real briefly by going through these what we're talking about with the definitions. So a contract is ratified the date of delivery. Now you'll notice the word delivery is capitalized. Anytime the word delivery in this contract is capitalized, that means it's in reference to whatever stated in paragraph 6 of the contract. We're not going there right now. We will cover that paragraph. But if it's a capital D, that's where it has to go. If it's a little d in delivery, then you can't go by the definition buyer and seller agreed to, because it was probably defined in statute, such as homeowners docs, POA and condo. It's a little d in the word delivery, because that is defined in paragraph 8 and 9 themselves. Okay, and so final acceptance in writing by buyer and seller of all terms of this contract to buyer and seller. If there's a counter, okay, by either party, that can be withdrawn at any time up until it is signed and delivered in accordance with paragraph 6 of this contract. Okay? The flip of that, and I believe we discussed this in a prior session, if there's a contract out there that's been countered, and your buyer or seller no longer wants to entertain that counter offer or that contract, you need to write void on the front of that first page, have everybody initial it, and send it back to the other party. Put something in writing that they have withdrawn that counter offer. Otherwise, it could be accepted after your buyer has already gone out and bought another house, or the seller, unless there's a time limitation. And we'll cover that as we go through this contract, okay? Not the date of expiration or removal of any contingencies. So a house is sold when a buyer and a seller have signed and delivered all terms and conditions of the contract. When is the short sale ratified? So when is a short sale ratified?
When the bank sign up the contract, put the
No.
signature.
Third party.
No, when the seller signed.
Okay, so bank approval for a short sale is nothing but a contingency. So even in a short sale, who still owns the house? The seller. And who's buying it? The buyer. At that point, you have ratification, okay? So it's not bank approval. Bank approval is a contingency, just like financing, appraisal, all the others. So that's what they're talking about here, not the date of expiration or removal of any contingencies. And when we look at the earnest money deposit, if you have a short sale and the seller has ratified it, then your buyer's check has to be in the bank within 5 business banking days of that point. That's ratification, unless your contract contains another clause extending the dates until bank approval. Okay, so it's imperative that we understand when a contract is ratified, especially when it comes to those earnest money deposits, etc. B, paragraph B, appraisal. That means a written appraisal of the valuation of the property. VA, FHA, conventional loans are going to have it, but we've looked at in previous weeks, we looked at the appraisal form for a cash transaction. A lot of people say, well, I'm offering cash, but I want to make sure it's still worth what I offered. So we do have that. Days or days, this is real important, means calendar days unless otherwise specified in this contract. Saturday and Sunday are a calendar day, okay? So unless it says business banking day, like for the earnest money deposit, business banking day, that would not count probably Saturdays and Sundays, but look for that, definition, unless otherwise specified, a day isn't any calendar day, okay? Now, paragraph D, all references to the time of day shall refer to the time of day in the Eastern time zone of the United States. If the contract says 9 p.m. and they're in California, come 6:01 their time, the contingency or the contract is dead or whatever. So it's, remember the time zone that we're working with. E is another one that's important that you understand. For the purpose of computing time periods, the first day is capitalized, okay? First day will be the day following delivery, and the time period will end at 9 p.m. on the day specified. So if the word day is capitalized in your sales contract in whatever paragraph we're looking at, then the first day is the day after you deliver. So if you're delivering your home inspection addendum and it has a capital D in day, you deliver it today, the first day is Friday. Okay? If it's a little d, then it's probably that day. So with POA and condo, okay? POA and condo has a little d in day. So that starts the day delivered, okay? So if it was POA and condo docs, you receive them today, the first day ends tomorrow, and I would say at midnight, but we'll discuss that when we look at that paragraph, okay? So you have to understand the difference between the capital letter and the small letter. You cannot override statute with a capital letter. So even if we wanted to change the delivery of the condo and POA docs to a capital D, so it starts the day after, we could not do that. The law does not allow you to change the definition of the law by contractual agreement. Everybody okay with that? The masculine includes the feminine. I think you're okay with that. Paragraph G, legal expenses. Now this is addressed in the default paragraph and breach paragraphs of the contract. Means attorney fees, court costs, and litigation expenses, if any, including but not limited to expert witness fees and court reporter fees. I used to go into court as an expert witness. I've stopped doing that now, but I was getting quite a bit of money per hour, and that was included in the definition of legal expenses. So if you're under the breach paragraph, if your buyer wanted to sue the seller and they called me in as a witness and they won their case, then the seller would have to reimburse them those fees. So legal cost, anytime you see legal expenses, remember this definition. Another very important definition, H, notices, means a unilateral, one-way, unilateral communication from one party to another. All notices required under this contract will be in writing and will be effective as of delivery. Okay, so if we send it today, it's effective right then. It's not the next day, okay, because it's defined that way. Written acknowledgement of receipt of notice is a courtesy, but it is not a requirement. I've been asked, would an email suffice as, a notice? Well, that'd be up to a judge, but my interpretation probably, simply because it was in writing and it was unilateral. I would like for you to go to page 38 of your package there, and the numbers are at the top of the package there, okay? And just for a second, go to page 38. It's called Notice Voiding Contract. Okay, this is an example of a notice. Anytime this contract calls for you to send a notice, not an addendum. Okay, notice is unilateral, an addendum is bilateral. All parties would have to agree. So, like for home inspection contingency, you want to void your contract. Well, then you would use the notice voiding the contract form on page 38. That's the written notification that's required, okay? And under paragraph 10 of the contract, we will discuss that further. All right, so a notice is a written notification. Should say notice on it, not anything to do with an addendum, all right? And then the definition of buyer and purchaser, you can see. Paragraph 31J, we will cover that when we look at paragraph 2 of our sales contract. Now, there's one other way of setting a definition in this contract, okay? Another way of setting a definition. If you go to page 1 of the contract, and that's where we're going to start now, page 1 of the contract. And it says here, this sales contract, you see the word contract in quotation marks. That is setting a definition. That is this entire document, including any addendums, is offered on. See that blank? Date of offer. Since date of offer is in quotation marks and capitalized, that is also setting a definition. So if you put today's date in there, what is it, the 9th? So if you put 7/9/2020, that is now a definition. So anytime this contract refers to the words date of offer in capital letters, they are referring to whatever's in that first blank, not date of ratification. They're talking about that first blank. And there are 2 places in this basic contract that you will see the words date of offer, that definition. When we look at it, paragraph 10, one of the choices under paragraph 10 for condition of the property is date of offer. And I am kind of shocked at the number of people that think date of offer was when the seller and buyer ratified. It's not. So the condition of the property would be the same condition it was on, the date in that first blank. The other would be paragraph 24, and that is the compensation that we are entitled to as agents. It's not when you showed the property. The contract is very specific. The amount of compensation offered by the seller on the date of offer, whatever's in that blank. okay? So pay attention to that blank. It's a definition. We will go into that in greater detail when we get to those paragraphs, all right? Between, okay, buyer. Whatever way the buyer wants the property titled, I recommend whatever's on their driver's license, that is what they're going to show at settlement, and how they want it titled. If it's a husband and wife, I usually put their names, husband and wife, beside it, simply because that's instructing the title company that they probably want it entitled by the tenants by the entireties. They will double check that, but sometimes they have different last names, and if that's the case, then and their husband and wife may want it tenants by the entirety, just helps out. Now, if this buyer or seller is a corporation, okay, or an LLC, you need something from that LLC approving the purchase or the sale of the property, okay? You need a resolution, and even if it's a one-person company, you need a resolution showing that they've approved the purchase or sale of this property along with their corporate paperwork. It's going to be needed, all right? And seller. Seller should be whoever is showing up on the title or the tax records when you research it.
Larry,
However,
excuse me, Larry.
okay.
Resolution, I never did anything with resolution. Is it supposed to be some standard form or?
It's just a corporate resolution. It says it says corporate resolution on the top. They drafted up that the corporate has, you know, approved the purchase to move forward the purchase or the sale of the property. Okay, so it's you know, just a pretty, you know, just something they draft up, and it would be in their records. Okay, should be showing in the minutes of their corporation. The other thing is to make sure you check with SCC and see if their corporation is current. Okay. Now, the seller, if you look at the listing agreement and it shows a Mr. and Mrs. Anderson own a property, but only Mr.'s signature, a name is showing up as the seller, I would contact the other agent before I wrote and ask why the tax records show two, but only one person selling, simply because the tax records are behind. I know this happened in my divorce. I got the house, and it took 6 months for it to show that it was just me as the owner. So there might, you know, that way that they can say, no, we have the divorce decree, we have the agreement to, you know, signed by the judge, etc. But it doesn't do any good to write a contract on a house that can't be sold. Okay, and the seller should be just the way it's reflected in the tax records. Now
they have to show that Larry, they have to show the, I mean, the other name also. If the name is on there,
if both names are in there, but they have some kind of a document that says that the property's been transferred to the other and signed by a judge, then both names doesn't need to be on there. I had one of these 25 years ago where contract came in and the agent had added the ex-husband's name, and when they did that, it was Carter was president, so you know we were in a kind of a tough market. The seller turned down the contract, and it was the only contract we had in 4 months because her husband's name was on the contract. And I mean, she would not change her mind. She said, I will not deal with that agent because it should not have shown that name. So it can cause problems, okay? It took us another 3 months to sell it for less money, but she didn't care. So I guess that wasn't too pleasant of a divorce, right?
So Larry, with a death of a spouse, if you will, or a co-owner, all that needs to be provided is a death certificate.
Yeah,
if the other name is still on the tax record.
Yeah, they're going to require an original copy of it. So when people, if you list a property in that situation, ask them to go ahead and do it.
Okay.
I couldn't find the one from my mother when we were selling some land for my dad, and I had to go to Richmond and to their vital records section and sit there all day to get a copy of her, certified copy of her death certificate. So, and it's not a pleasant thing to think of, but just like with my father passing away, I asked them to give me 10 original copies, which, you pay for, but we had them. So we could supply them to all the estate things without having to, go back through that.
And who do you provide that to? The settlement company?
The title company's going to want it.
Okay.
But, as a listing agent, you should be asking for that up front so that everything is prepared to go. And that shows that you know what you're doing. Even though it's not a pleasant topic to have to address with people, it shows that you know what you're doing. Okay.
Thank you.
Since we're going to need this anyway, let's have it. Corporate resolutions, whatever.
So Larry, if the buyer is writing the contract and the seller has both names on it, and he says, he signs, one person signs it, so that we can ask the listing agent for that one, why this name is on it?
Well,
not on it.
Look, you should be checking the tax records before you write a contract. And if it shows two names and the listing only shows one, call the listing agent right up front to ask, why the other name doesn't need to be on there. Okay, don't automatically add it because it could tick somebody off.
I see. Okay? Unless they have a quit, they have to show the quit form, right? Quit.
They don't have to. They don't have to show it, but if they enter a contract under false pretenses, then we have a different situation. I'm just saying, don't automatically add the name just because it's in the tax records. It could be a very good reason why it's not included. I've had several cases of that in the 43 years I've been doing this, and it's not pleasant. It's usually a divorce.
Larry, sometimes public record is cutting off one of the name, and if it will be 3 names on the public record, how can we find it out exactly how many people involved?
Well, you have to call and ask the other side, because if it says et al., Larry Anderson et al., that means there's more than one person in addition to me, and they don't list them all. So like for the estate for my father, all the property, the houses and whatever has to be signed by everybody. So there's 6 people that have to sign the listing, the contracts, etc. So the contract was made out to the estate of Russell B. Anderson, but it had to be signed by all the heirs. We could have gotten one person to have power of attorney, but generally in these situations, there's always somebody not happy, so you're better off getting everybody to sign. I'm filing a report with the county today or tomorrow when I go down, my administrator's report for the second reporting, and I had every heir sign every receipt, every deposit slip, etc. Because even though I'm the administrator, I want everybody agreeing that all these expenses were approved, and I checked with everybody because I don't want any problems. Right now, I'm the only person still talking to everybody in the family, and I want to keep it that way. Okay, so
Larry, when the listing agent say, they have the divorce and they have the paperwork, we should not take it. They're right.
I'm taking. You can ask for them if they would send it over, but that's person's private, personal information, which they can't give you unless the party agrees to give it to you. All we want to know is, yes, we had the paperwork, and the attorneys will have it at the end because they need it also. Okay. I'm going to give them the benefit of the doubt. Okay. And remember the form that I shared with you, the new form that came out, and it's called Information for Making an Offer, and it's optional. Look, Fairfax Realty agents, we're becoming known as the cream of the crop out there, the best agents out there. So why not just go ahead, use the information for making an offer optional, fill out the information, and a space there for seller's name, okay? All the information they need to fill out the contract properly right up front is on this form. You download it into the MRIS, So if you take a listing and there was a divorce and the judge has signed off on the property settlement agreement, then just put the name on here and say, you know, property settlement agreement if the seller allows you, or contact the agent so that they know, okay? So a lot of stuff we're going to talk about going through this contract, you could find if agents would start using this information for making an offer optional and it doesn't become part of the contract. It's just to help you fill this out.
Okay. Thank you.
Okay?
Thank you.
Good. Now,
this is the NVR form, yeah?
it's an NVAR form. It's a new form that came out April of 20. And we did go over this form in a previous session, so you can probably find it on our YouTube channel, but it's form K1385. K1385, and it covers all the information. It's 2 pages of great information, so we don't have to guess when we're writing an offer on your contract. We can get it done in one shot. Everybody agrees, and we're not wasting time going back and forth.
Thank you, sir.
Okay? All right. Now, back to this first paragraph. By prior disclosure in the real estate transaction, the listing broker represents the seller. So that's your listing agreement. That's the prior disclosure, okay? And cooperating brokerage represents buyer or seller. Now, the cooperating brokerage, in my opinion, I'm a strict constructionist, but our law says the only way that I can represent someone is with written agency relationship. There cannot be sub-agency in the state of Virginia. So you would not be representing the seller if you're not with Fairfax Realty, okay? You'd have to have a buyer-broker agreement, and so by previous disclosure, that would be your buyer-broker agreement. You represent the buyer. You should never be representing the seller on another company's listing, okay? Now, little technicality. If it is a Fairfax Realty of Tyson's listing and you're a Fairfax Realty of Tyson's agent, okay, you could have a customer without having a buyer-broker agreement by getting the disclosure of brokerage relationship form signed, and you would still be representing the seller, but there would not be a co-op broker. At that instance, everybody is representing the seller. So it would just say represents the seller, Fairfax Realty of Tyson's, and co-op broker would be not applicable. There is no co-op broker if it's one of your own company listings and you're not a buyer's agent. If you're a buyer's agent with Fairfax Realty of Tyson's, Fairfax Realty of Tyson's listing, then you would fill that paragraph out. And on a Tuesday session, I will go over the difference between client, customer, and when you would do that. Okay, now this is pretty important. The listing brokerage and co-op brokerage are collectively referred to as broker. So anytime you see that in there, word broker capitalized, it's either the listing company or the co-op company. If the brokerage firm is acting as a dual representative for both seller and buyer, then the appropriate disclosure form is attached to and made part of this contract. If you are doing a dual agency or a designated agency, then that form has to be attached to this contract, okay? Now, the statute in the state of Virginia, which I'll go over in another session, but briefly what it says, you can't do a dual agency until all parties have agreed in writing before you start writing the offer. So page 37 has, or 36, one of them has a dual agency disclosure form. So page 34, okay? You go to page 34, you will see the disclosure for dual agency. In 35 and 36 would be designated, etc. So this form has to be filled out and attached to and made part of this contract before you start writing the offer. Matter of fact, when we take a look at the statute in a later session, it specifically says that if it's just disclosed as part of the contract, that wasn't disclosure. Okay, so that is for another session. Just be aware, has to be attached to and made part of this contract if you're doing designated or dual. And the reason designated has to be added here, the broker is still a dual agent. So even with designated agency, it is still a dual agency situation. Okay. In consideration of mutual promises and covenants set forth below, and other good and valuable consideration of the receipt sufficiency of which are acknowledged, the parties agree as follows. So in Virginia, is an earnest money deposit required to have a contract? What do you think? Well, I'll think for you. No. Okay. It's nice to have, but in Virginia, it's not required. But if you do receive it, that is receipt sufficiency of other good and valuable consideration. But your handshake and signature in Virginia is binding for a contract. Let's take a look at real property paragraph. Paragraph 1. Buyer will buy and seller will sell for the sales price, and there's that capital letters and quotation marks, seller's entire interest in the real property with all improvements, rights, and appurtenances are described as follows. And you see property is quotation marks and capitalized. So anytime you see the word property throughout this contract, it's referring back to the property being sold. So what is an appurtenance? If I turn to you as the buyer and I say, what appurtenances am I getting? I guess the best answer, if you don't know, is all of them that are here, you get them, whatever. But what is an appurtenance? Well, an appurtenance is a right or interest that goes with the property. My air rights, my water rights, my mineral rights, oil, gas, support rights for supports for my structure. Those are all appurtenances that come with the property unless the owner no longer owns them. I live in a town called Mineral, Virginia. And why is it called Mineral, Virginia? Well, it was a mining town. I don't know that I own the rights to the minerals under my property. I bought my property in an auction sale. It would not be something that would have shown up. So if I were to sell my property, I might cross appurtenances out. Or say, as a disclosure, I'm not sure if I own the mineral rights. That is something that the buyer needs to check out on their own. Okay. What about rights? What rights do I get? Well, if you think back to principles, rights are the right to possession, use, and enjoyment. I can encumber at will my property. I can will it to somebody. Those are my rights that come along with it. And improvements or anything that's been added to the property. Okay. Now, most of this information you will you retrieve from tax records, but a lot of it's auto filled for you if you're using the system. Tax map ID number, legal description, that's lot, block, section, subdivision or condominium. Can it be both? Yes, I mean, think of some of the Reston has condos that are within their association. How many sets of documents are you going to need? 2, right? So it could be both, okay? Parking spaces. This is one that you've got to pay attention to, okay? We need to know if it's owned by deed, okay? By limited common element, or just assigned. So when you see the parking space, don't just, don't put just one space. I usually put the parking space number. But when you list the property, especially, these older condos in Arlington, in Alexandria, the older condos, you could actually buy the condo and then buy a parking space. So you had two deeds. I've known people that sold their condo, moved out to the suburbs, but retained their parking space because it was separate deed, because they were still going to be working in Crystal City and they wanted to park there. Okay, so assigned is the association says you get space 21. Does it stay 21 or does everybody move up? You need to know. But the one we're finding to be a problem, limited common element. The newer condos, I do not receive a deed to the parking place. It is part of the limited common element. I have the right to use space 3 as part of the condo docs, okay? And things recorded with the county. Well, say I don't drive. I don't drive. I don't need the space. You would like an additional space. So we don't know the difference. We just draft up a bill of sale, simple deed, and you buy the space from me for $20,000. You go to the courthouse, you record the deed, they don't care, okay? Now, I sell my condo 3 years later. You go to park in the space and somebody else is getting out of the car, and that's the new owner of my condo. You say, wait a minute, that's my space. I said, no, I got that as my limited common element. But I bought this from Larry 3 years ago. Who owns the right to that space? The person with the deed or the limited common element?
Limited common element.
The limited common element owns it because I never owned it. I couldn't sell it. If I never had a deed to it, I can't sell it. Okay? So why didn't it show up in the title search? Well, it's in a different chain of title. So if your person's getting cheap and they don't want the best title search there is and willing to pay for it, this is something that might not show up. So when you list the property, make sure you check with the condo association or the management company as to the ownership of this. Ask the seller. They may not know, but find out. We don't want this problem later. Okay. County or municipality. This is another one that sometimes gets messed up a little bit. It may have a Fairfax City of Alexandria mailing address, okay, but it's in the county of Fairfax. The post office is the City of Alexandria, so the county municipality may not be the same as the mailing address. When you come across out of Alexandria on Route 1, people there have a City of Alexandria mailing address, but they don't live in the City of Alexandria. I learned this lesson 42 years ago with a broker I worked for out in Herndon when I started. He actually bought a property back because the people wanted to live in Reston, and the house they were sold was really in Herndon but had a Reston mailing address. And rather than fight it, the broker bought the property, and we sold, so the company sold them a different property, and then the owner flipped the property. But don't get tripped up by that. Okay, deed book is called LIBOR, so that's where you could research all this stuff, page or folio. Now the street address is the mailing address. Okay, so verify the mailing address and the zip code.
Larry, I didn't understand what you said just now for the, what happened, how it got the one which you're saying.
In Reston, the people specifically requested to live in Reston. Back then, 42 years ago, utopia. It was a desired neighborhood, desired place. The mailing address of the property said Reston because that's the post office that serviced the house, but the house they bought was really in Herndon. So they were going to sue the company because they didn't get a house in Reston. just the mailing address. So,
So
the
address,
brokerage-
even if the property address is different, the actual address will be different. That's what you're saying?
well, you need to check and make sure where it's really located. Okay. So just because the mailing address said Reston doesn't mean it's in Reston. That's where the post
How-
office is.
How do we check it out, that one?
Well, check your
County?
check your legal description. It will show you.
Oh, tax records. Okay. Mhm.
Okay.
Mhm.
Okay. Good. Any other questions about that?
Larry, going back,
That's the boilerplate kind of stuff that we look at and we don't really go over, but you really do need to make sure you pay attention to this. And on this form for information for making an offer, that whole section right there is one of the things that you would be disclosing to the other agents to help them fill that out properly. Yes, have a question?
yes, I just want to go back towards the title search when you said if the owner is trying to be cheap and get a cheap title search. So how can you know if it's
Tell them you want the Eagle search.
What is it again? I'm sorry.
Tell them you want the Eagle search.
Okay.
The Eagle policy versus the enhanced policy. Yeah, the basic.
Yeah, it's the enhanced. And actually the sales contract and the other disclosures paragraph talks about, they're going to quote them that policy, but they have the option to say, no, I want, something else. So on page 11 of 13 of your contract, it says buyer may purchase title insurance at either the standard or the enhanced. You want the enhanced, okay? Then that goes out and searches everything about that property, okay?
And is there something for us to learn more about how title search is done and what's the process for agents?
Well, actually, the way I've got this set up is I'm going to continue to go through these basic classes on Thursdays to make sure everybody understands. And one of the ones I've asked RTS to help me with is what to expect in a settlement, how it happens, and the searches, etc. So agents have a better understanding. So a future session will be on settlements.
Thank you.
Okay. This is going to be a labor of love here, getting through all these forms and listings and all the basic stuff. But once we have it recorded, it'll be up on the site for any new agents or just a review by agents. Okay. All right. Paragraph 2 of the sales contract: price and financing. Okay. You notice the words price and financing are capitalized, right? So there's a definition later in the contract. Any percentages are percentages of the sales price. Now, I'm not a big fan of the percentages. I know most agents like to use percentages, but I'm not a big fan of percentages. But let's try one of these to fill it out, okay? Let's try filling one of these out. We're going to do what we call an 80-10-10 transaction for a sales price of $200,000. So sales price $200,000 goes in the blank that says $200,000. Now an 80-10-10 transaction, that'd be a 10% down payment. So where it says down payment 10%, financing first trust would be 80%. Okay. Second trust would be 10%. So that's the 80-10-10. Seller held would be 0. Get in the habit of not leaving any blanks in your contract. It's either 0 or NA. Don't leave blanks, okay? So what would the total financing be? Well, 80 and 10 is 90. I quite often see 100% there. It would not be 100% unless it was a VA loan, right? So total financing is 90. Let's try the numbers for this. Down payment, the dollar amount, 10% of $200,000 is $20,000. The first trust, 80% would be 160,000. Second trust would be 20,000. Seller held would be 0. So total financing would be how much?
180.
180,
right?
Good. So here's a little tip. If you add down payment to total financing and it does not equal the sales price, please start over. You have a mistake, okay? So with the numbers, we can see it. Now, first trust financing was moved. There was a definition in paragraph 2. It is now under B. So that's where you check conventional VA, FHA, USDA, or other, okay? And if you're in an area that you can use a USDA loan, very good loans, very good loans. Maybe we'll have somebody address that one day in a session. Any problems with how to fill out A and B? Now, seller subsidy, okay? Seller subsidy is capitalized. There is a definition. They moved seller subsidy to this paragraph from your financing contingencies simply because it gives the seller a better understanding of what they're really getting for their property. I mean, back in the financing contingency, it might have said 3% in closing costs, but nobody really ever addressed it and said, look, you know, you're really getting $294 for this property. I mean, $194, not $200. So they moved it here. But go back to paragraph 31 for the definition of seller subsidy. Okay, 31J, okay, page 11 or 13 of your contract. Seller subsidy is a payment from seller towards buyer's charges, including but not limited to loan origination fees, discount points, buy down or subsidy fees, prepaids or other charges, as allowed by the lender, and that's the key, if any. Okay, so check with your lender to find out what they can use. Now, roughly in Virginia, I tell people your closing costs are going to be 3% buyer, okay? 3%. It's really about 2.88. If I use 3% and the lender won't allow them to use the other 0.12%, 1.2% or whatever, 1.3, then that money goes back to the seller. It does not go to the buyer in cash. It is the buyer's responsibility to confirm with any lenders that the entire credit provided herein may be utilized. If lender prohibits seller from the payment of any portion of this credit, then said credit shall be reduced to the amount allowed by the lenders. So we know that on a 5% down loan, conventional, the maximum allowable closing cost usually about 3%. Why ask for more than the law allows? Because the lender won't be able to allow it. Don't ask for more than you can use. You're better off probably reducing the sales price a little bit. Now, here's a problem that's been propping up. You do a home inspection, okay? You do a home inspection. You come up with a list of items. You send it to the seller. They come back and they say, we don't want to fool with all this. We'll give your buyer a credit of 2% of the sales price, and everybody agrees and we're all happy. Now, on page 1 of the contract, it was a 5% down conventional loan. You already got 3% in closing costs. Now, your buyer just agreed to take 2% more in closing costs to take care of all the problems in the home inspection. So basically what they just told the seller, you don't have to fix anything, and I'm not going to get the money to fix it either, because the lender's only going to allow the 3%. The other 2% is going to go back to the seller. Think about what you're doing when you get additional credits, when you've already asked for a credit for the closing cost. Loan programs might dictate you cannot use it, okay? And if they're not going to use the lender, that they met with you, they're changing lenders, your lender said they could use it, the other lender might not allow it. So think about those things when it comes to seller subsidy and closing costs. Now, paragraph 2D, financing contingency and application. This contract is or is not contingent on financing. If it's conventional, VA, FHA, USDA, it is. Cash, it would not. If this contract is contingent on financing, buyer will make written application for the financing and any lender required property insurance no later than 7 days after date of ratification. Your buyer actually has to contact an insurance company and apply for insurance, not take it out, but they need to know at that point whether or not your buyer is still going to qualify for the mortgage if the insurance is high. Now, what in the world could cause the insurance to be high? Well, first thing the insurance company is going to do is pull a clue report, comprehensive loss underwriters exchange report on that property, and it will show any work that has been claimed against that insurance, and that is going to actually affect, the insurance rate for your buyer. So if the previous owner has made several claims, your buyer's insurance is going to be higher. What else might cause it? Well, floodplain. If the property's in a
Larry?
floodplain. Yes.
Let me ask you a question. Let's say you're saying that a bank is going to apply for the insurance for that particular property.
No, the buyer has to apply for the insurance because the bank wants to know how much it's going to cost. Because your loan officer has to factor into their qualifying what the insurance is going to be. Now, when you first meet with that lender, they know what basic insurance is going to cost, but they don't know what's happened with the previous owner. They don't know if it's in a floodplain, any of those things that could drive the insurance up.
Okay,
So
my
that's
question
why,
is this: it's only for the previous owner, or can go to some other owner too when they verify that?
The clue report goes back. Clue report goes back 5 years.
Okay, thank you.
Okay, so 5 years for a property, 7 years for your driver's license. Okay, so when they run that clue report, anything that's been done to that previous claims, it may very well affect your buyer's insurance rate. Okay, so when I'm representing a buyer client, if it's not a multi-contract presentation, I generally insert a clause that says the seller has to supply a clue report to us within X number of days, that we have the right to void the contract if we don't like the clue report. How much does it cost a seller to get a clue report? Nothing. Okay. You as a property owner, you're entitled to one free clue report on your property each year. It's part of the Fair Credit Act. So you should be getting one of these every year on your property and make sure there's no erroneous claim.
Where do we get it? Clue report from the
Google get a clue. Okay.
Okay.
If you Google get a clue, it will take you to LexisNexis website. Okay.
Mm-hmm.
You scroll down until you find the free report, because they'll try to sell your report, but you're entitled to a free report each year. It's part of the Fair Credit Act.
Your homeowner's insurance doesn't give you, or
No. Okay. So you could probably ask for it from your insurance company to see if they'll provide it to you, but you're entitled to one free clue report as part of the Fair Credit Act. Look,
it's clue spelled C-L-U-E or C-L-U?
C-L-U-E.
Thank you.
Comprehensive Loss Underwriters Exchange. Okay. Now, as far as floodplain, if you go into our RPR system and you do a property report, and if you don't know about RPR, we'll discuss that in another session.
Real property resource.
Yeah. So RPR, okay, do a property a property search on that address, and part of what it'll pull up, you can check the floodplain in a matter of 3 minutes, okay? So you should know whether a property is in a floodplain before you list it or before you write an offer on it, okay? Now,
So
the other thing that affects your insurance cost is your credit report. If you got a lower credit score than I do, you're going to pay more for your insurance than I do. Okay, it's all tied to the Fair Credit Act. If you ever had anybody receive a call from their insurance company that says, "Okay, we have to come out and do the annual inspection of the house," they've never done one in the past, I can guarantee you their credit score is taking a big hit somewhere, because they do follow that stuff. And they want to make sure if you're having financial problems that you're keeping your house up. Okay?
so Andy, Anson, so you're trying to say that buyer agent should check the clue report, insurance clue
Well, you
report?
can't get it, but you can always write a contract clause in your contract that's contingent upon the seller getting it and supplying it to you.
Okay.
Look, what is the clue report going to show? Well, what if there's been a fire in the property and the property has been repaired? Does the seller have to tell you about that fire in their property?
No.
If it's been repaired, does the agent have to tell you? No. But I mean, if it shows up in the clue report, it's going to be there for 5 years. Maybe that'd be important to your buyer. I don't know. Or maybe they've had to fix the pipes 3 times in 1 year, or a roof claim 3 times. I mean, there's some things that show up that the buyer might want to know. But if it's a multi-contract presentation, you're asking for a clue report, you know, it may not fly. But if you apply for your insurance in that first 7 days, then that is going to show up to your insurance company when they make a quote. So they'll be telling you about it. Okay? And the 7 days matches up with the 7 days to make a loan application.
Larry, are you
Yes.
are you recommending or suggesting that we write that addendum in our contracts for the clue report on every contract?
Well, I'm not telling you to do it. I do it with all my clients.
Oh, okay. So you do it with all your clients. Okay.
Yes. I mean, I go over it with them. But, you know, if it's going to be a multi-contract presentation, that might be the thing that kicks it out. So you got to go over all that with them.
Okay.
So buyer agent cannot ask the insurance people that.
No, the
clue
buyer
report
cannot ask the insurance company for it. Now, when you apply for your insurance, they might say, well, there's been a lot of claims against the property, therefore your insurance is going to be $300 more per year than what you thought.
Larry, I have a question. You said something about if there's a fire on the property,
Yeah.
the seller doesn't have to tell you about it. But if the seller tells the listing agency, doesn't the listing agency, aren't they obligated to tell the buyer agent or the buyer?
Not if it's been repaired.
Not if it's been repaired.
Our law says I must disclose all known material adverse facts. If it's been corrected, it's no longer an adverse fact.
Same if the basement flooded and they had it remediated?
Yeah, I mean, if it's been remediated, they have receipts and everything, then it's no longer a known material adverse fact, unless it happens, you know, on a regular basis, and they just have to keep getting it repaired. And remember, it's not a defect; it's an adverse fact about the physical structure of the property. Once it's corrected, that fact doesn't exist, then maybe it's not, unless it's a recurring thing. So, say that I've repaired my roof 4 times already this year, okay? And it's only July, and I'm a seller, and I had to repair my roof 4 times. Seller doesn't have to tell you that, but if you're the listing agent and you know the roof's been repaired 4 times, okay, but it's not leaking right now, well, there's no defect. But if you're a buyer and you knew the seller had repaired their roof 4 times, and it could happen, likelihood it's going to happen again, would you buy that property knowing that? If not, that's a known material adverse fact. So as a listing agent, I'm probably going to say, look, you know, this roof has been repaired 4 times this year. There are no current leaks, but I'm not taking the risk. So it's known material adverse fact, not defect.
Okay,
Okay?
yeah, thank you.
The rest of paragraph 2 here, buyer grants permission for co-op brokerage and the lender to disclose to listing brokerage and seller general information available about the loan progress of the loan application, the loan approval process. They don't have to give you that information, but if they will, you have the permission here under the contract. And seller agrees to comply with all reasonable lender requirements. So, I mean, that could be just about anything. So, good questions today, and that's what this session's about. Okay.
Larry, can I ask you another question?
Sure.
This is about listing for rental. Is that the same as listing for sale?
In what respect?
Like owner exclusive right to listing, owner's representative?
Yes.
Okay.
There's one other thing that you do have to disclose now under the property condition is if you know there's any lead pipe or fittings or anything.
We have to have a lead base, but what is
not
the
not
thing?
lead-based. This is not lead-based paint now. I'm talking about the lead in the drinking pipes. So it's a new requirement, and it's in the agreement now for listing a rental property, and it's in the lease. So,
So can I do a disclaimer?
No, you can't disclaim. You'd have to disclose if you know it has it. And look, our law says we only
if I
have
don't
to,
know if you have it, then
well, that's what our law says. Known things that you know. If you don't know, you don't have to disclose in Virginia. We don't have know, could have known, might have known, or anybody else in the world knew like Maryland. Virginia, our law specifically says I have to disclose known things that I actually know.
So
Okay?
what is there a form for the lead in the pipe?
Yes, there's actually a disclosure form that DPOR's putting out now. So it's one of those, if you go back to one of the previous sessions, I discussed all the things that have to be disclosed in under the new statute.
So if I don't know if there's a lead.
Marine clay, this pipe, and actually there's no longer a one-page disclosure form for Chinese drywall. That's into the ones where you have to figure it out yourself things. So, but there was a previous session that's saved on YouTube. You can go back and hear all those things that changed this year.
So if I don't know if there's a lead, I don't need to have that disclosure, right?
No, and it's not a disclosure you make, it's a disclosure the owner makes.
Yeah, I'm the owner, sorry.
Yeah, oh well. And if you don't know, you can't tell, right?
Right, so I don't need that form at all.
No, not unless the form is if you do have it.
Okay, great, thank you. That's all I'm trying to make sure I cover my bases. Thanks.
No. Okay.
Mr. Anderson.
Yes, sir.
I got a question. Once we fill out the contract, we have the pre-approval. Buyer has the pre-approval letter, and he changes the bank. Does we have to disclose with the other people that other seller side, that agent? I mean, that
no, not unless it's past the 7 days.
Okay, if past 7 days, we don't have to.
If it's past 7 days, you do have to. It says they have 7 days to make loan application. And I am going to cover that when we pick up on the session next Thursday. Okay. I'm keeping these to an hour or close to it so that I don't overload you. But we will look at the financing addendum to tie back into paragraph 2 when we meet next week.
Okay.
And on Tuesday is Ask Larry. And Thursday we'll be picking up right here where we left off at paragraph 2. And we're going to keep going through until we get through the whole contract and all the forms that go with it. So I was glad to see so many people sign in to hear this. I do appreciate it. I know the managers appreciate it because it gives you a chance to ask questions that you might not have thought of. And hopefully I can throw some things out there you might not have thought of.
Right.
Okay?
Okay. Yeah.
I got a question. Larry, I got question 22. The possession date. If we go for closing, and the seller is not vacant the house, because it doesn't say vacant in this property. It says seller possession date, okay? And he doesn't vacant the property.
He's a holdover tenant at that point. You have to get him an eviction to evict him.
That takes long time to do it?
Well, today it will, because they're getting into court to do it. So hopefully they move out.
Okay. But,
okay.
Okay.
But that'd be something for Tuesday.
Okay.
But that can be, Larry, that can be done like post settlement also, right? Rent back or something like that. You can do it.
Well, after settlement, if the people are still in the house, then they are holdover. They're called holdover tenants, and you can, at that point, go to get them evicted.
No, but the final, if you do the final walkthrough.
No, I don't know. I've answered it. I don't know any other way to answer that one. Okay. They're holdover tenants. You need to get an attorney involved to get them out of the house. Okay. If they don't leave, hopefully they've left. Okay.
Okay.
All right. So that is it for today. I appreciate everybody attending, and we can do ask Larry questions on Tuesday. Okay?
Is that Tuesday? Any questions?
Yep. Any question you want to ask
great.
on Tuesday? These sessions are more for going through the forms and all, make sure we understand them.
Okay, I'll try to save my questions on Tuesdays. Thank you very much, Larry.
And send them to me in advance if you want, so that I know what you're going to be asking.
Larry, I have an admin question. I tried to download the contracts packet, but it won't let me do it. It says I need authorization. The authorization failed.
Okay, you have to get, that's something that
yeah, who do I contact?
Jocelyn or Johanna or somebody would handle that one.
Okay.
Okay.
Thank you.
Thank you.
Thank you, Larry.
Thank you for attending.
Thanks, Larry.
Thank
See
you.
you guys later. Bye.
Have a good day.
Bye-bye, goodbye, everybody.